Hi, everyone. Thanks for being here today. I'm Becky Johnson, a professor of professional practice at Texas Christian University in the Department of Environmental Sciences. My background is soil and groundwater contamination and cleanup. I'm a strong believer in licensing and registration for professional geoscientists and have been registered in another state since 1992 and in Texas since we began licensure here. I have served on the Texas Board of Professional Geoscientists since 2011 and currently serve as the chair of the board. I know ethics resources are hard to come by, so I hope that you will enjoy what we discuss here today. I'm going to start with two famous key cases where geologists were key in the investigations, and then we'll talk a little about the American Geosciences Institute ethics guidelines, followed by some day-to-day ethics, and end with what I like to call geoscience on trial. We'll talk through a few case studies, and including some of those that we see at my agency, the Texas Board of Professional Geoscientists. The two environmental disasters I'd like to talk about are Love Canal and Hinckley, California. In both of these disasters, geologists were key to proving where the contaminants originated. Let's talk about Love Canal. It's located adjacent to Niagara Falls, New York. It was a small neighborhood, just 36 square blocks, with about 70,000 residents. It was named for William T. Love, who envisioned a 4-mile-long bypass canal between the upper and lower Niagara River that would allow ships to bypass the falls. By 1910, Love had completed 1 mile of canal, but he gave up. He had no financial backing and none of the powerful trenching equipment we have today. By 1920, Love's land was auctioned to the city of Niagara, who said, "Look, a big hole in the ground. Let's put trash in it." They used it for chemical waste disposal from Hooker Chemical. In 1942, Hooker Chemical, who later became Occidental Petroleum, bought the property and continued to dispose of chemical wastes, including 21,000 tons of things like benzene, PCBs, and dioxin-tainted trichlorophenols. By 1952, the site was filled to capacity, and Niagara School Board acquired the site from Hooker for $1 to build a new school. It came with a disclaimer. The grantee, the school board, has been advised that the property is filled with waste products from the manufacture of chemicals, and the grantee assumes all risk and liability. Even the school board's counsel stated that this property would pose an undue financial hardship, and the construction company also advised against building a school here. In 1952, the construction began on the school, but they found a chemical pit, so they moved the school directly over the landfill. The school opened in 1955, and chemical seepage into basements of nearby houses was reported by 1959. In the 1970s, studies showed numerous toxic chemicals in the nearby waterway, Black Creek. The neighborhoods had high cancer rates and birth defects. The surface of the landfill collapsed and exposed drums of chemicals in 1974. New York Department of Environmental Compliance documents said there was widespread contamination of sewers and sumps by 1976. But the homeowners couldn't prove that the chemicals on their properties came from the landfill. In other words, they couldn't prove liability. By 1978, geologists had identified the migration pathways from the landfill to the residents, proving that the contaminants were from the landfill, that they seeped into basements and volatilized into the air, and they identified an old sand-filled stream channel that crossed the canal, or the landfill, and that was the source of the highest concentrations of contaminants. By 1978, the school closed, and the governor ordered the purchase of affected homes. Between 1978 and 1980, Jimmy Carter declared an environmental emergency for 350 acres. EPA evacuated 950 families from a 10-block area, and by 1980, DNA damage was proved. Remember, we didn't have DNA testing back then. This was a brand new technology, very difficult and very expensive. Love Canal became the world's first Superfund site. And here are a few photographs from the neighborhood and the landfill where the drums were exposed. Remediation of the site included demolishing the houses and capping 40 acres with a synthetic clay liner. They also surrounded the site with a leachate collection and treatment facility. EPA finished the cleanup and delisted the site in 2004. They sued Occidental Petroleum, who had purchased Hooker, and recouped expenses. Occidental paid $129 million in 1995. Today, the site has been redeveloped as a neighborhood called Black Creek Village. 200 abandoned homes have been renovated and sold to new owners, and there are 10 newly constructed apartment buildings and new light industrial commercial area to the east. Next on our list is Hinckley, California, probably more well known as the Erin Brockovich case. Hinckley is located just outside of Barstow, California, about halfway between Las Vegas and Los Angeles in the Mojave Desert. Their drinking water was groundwater, and it was contaminated with hexavalent chrome or chrome-6 by Pacific Gas and Electric, PG&E, at a natural gas compressor station where chrome-6 was used as a corrosion inhibitor. Chrome-6 contaminated wastewater was dumped into unlined ponds at a rate of 750,000 gallons a month since the 1950s. That wastewater percolated into the groundwater. There was no barrier between the ponds and the sole source aquifer for the town. Internal documents at PG&E indicated concerns over chrome-6 in 1965. By 1972, they had dumped 370 million gallons of chrome-6 wastewater into the ponds. To put that in perspective, that's slightly more than the Deepwater Horizon release. Also by 1972, PG&E lined the ponds and continued to dump another 54 million gallons over the next 6 years. By 1987, PG&E reported to the state that chrome-6 was detected at 10 times the cleanup standard in wells north of the wastewater ponds. PG&E's strategy was to buy all the surrounding properties at above market prices. Groundwater concentrations of chrome-6 ranged from 580 to 1,000 parts per billion. EPA limits total chrome to 50 ppb and limits EPA limits total chrome to 100 parts per billion. California limits total chrome to 50 parts per billion and limits chrome-6 to 10 parts per billion. Chrome exposure in humans and animals targets lungs, liver, kidney, spleen, adrenals, plasma, bone marrow, and red blood cells. PG&E hid the crisis and misled the town on the effects of chrome-6. They even denied that chrome-6 was possibly connected to the health problems in the town. Specifically, the residents experienced liver, heart, respiratory, and reproductive failure, cancer of the brain, kidneys, breast, uterus, gastrointestinal system, Hodgkin's disease, and frequent miscarriages. Animals in the town were also sick and dying. Trees and plant life were also suffering. Today, Hinckley is the world's largest plume of chrome-6. It's 8 miles long by 2 miles wide as of 2018. The lawsuit brought by Ed Masry and Erin Brockovich was won in 1996 with a total award of $333 million, the largest settlement in U.S. history until the Deepwater Horizon. PG&E also paid $295 million in 2006 to settle other cases for 1,100 people in other towns, and they settled the last of the Hinckley claims in 2008 for an additional $20 million. So all total, $378 million to date. So these two cases clearly demonstrate that geologists protect the public and health and safety by knowing and understanding the subsurface, identifying pathways for contaminant migration, and identifying modes of exposure. So next, I'd like to move to the discussion of the American Geosciences Institute and their ethics guidelines. AGI represents and serves the geoscience community by providing collaborative leadership and information to connect Earth, science, and people. Their vision is a world that understands and trusts the role of geosciences in fostering creative solutions for Earth and humanity. AGI has over 30 member organizations in their network that emphasize the shared interests of a diverse, vibrant community. AGI established the ethics guidelines because, and I'm paraphrasing, geoscientists play a critical role in ethical decision-making and should adhere to the highest ethical standards in all professional activities. Further, geoscientists must earn the public's trust, engage responsibly in the conduct and reporting of their work, and respect the work of their colleagues. Some of their day-to-day guidance includes be honest, act with integrity, distinguish facts from interpretations, do not plagiarize, disclose conflicts of interest, and assist in the development of a safe, diverse, and inclusive workforce. They promote a greater understanding of the geosciences. They recognize the uncertainties of Earth systems and use their skills to protect public health, safety, and welfare. Next, I'd like to take that day-to-day ethical practice a little further. Ethics are generally thought of as a set of values that define or direct us to the right choice. Most people don't make much of a distinction between morality and ethics, but I'm going to. Morals describe your own private beliefs. They are not a legal requirement. They may be based in religion or societal customs. Some may think of them as simply knowing the difference between right and wrong. Still others think that they should benefit the greater good or not. Some would argue that their own personal belief system should only benefit them. Ethics, however, must be congruent with your industry, so you may not be able to rely solely on moral right and wrong. Instead, business ethics require us to analyze all values and perspectives, regardless of personal moral beliefs. Further, they require you to act in the best interest of those you serve, your clients, employer, or regulatory agencies. So when you consider personal versus professional ethics, should religious or cultural beliefs influence your professional decisions? I leave it up to you to decide. I only raise the questions and provide some food for thought through the following example. The U.S. Health and Human Services established a new division in 2018 called Conscious and Religious Freedom Division. Its purpose is to restore federal enforcement of laws that protect the fundamental rights of conscious and religious freedom in the medical profession. Previously, healthcare workers were barred from refusing to treat transgender or abortion seekers. It appears that this new division is aimed at protecting workers who refuse to perform services that go against their personal religious beliefs. The ACLU published a statement that this allows religious liberty to override anti-discrimination principles. To add context, the same HHS office moved to allow employers to refuse to pay for birth control coverage in 2017. An excerpt from the director's statement says, "For too long, governments big and small have treated conscious claims with hostility instead of protection. But change is coming, and it begins here and now." An evaluation of this new division shows a strength in protecting the religious freedoms guaranteed by our Bill of Rights. The fear is that doctors and nurses could refuse service to anyone that doesn't conform to their specific personal religious beliefs. Conflicts between religion and science are nothing new. I found a few quotes from this 1875 book to share with you. Can we exaggerate the importance of a contention in which every thoughtful person must determine whether to take part? The antagonism we thus witness is the continuation of the struggle between the expansive force of the human intellect on one side and the compression arising from traditionary faith and human interests on the other. And lastly, as to science, she has never sought to ally herself to civil power. She has never attempted to throw odium or inflict social ruin on any human being. She has never subjected anyone to mental torment, physical torture, least of all to death, for the purpose of upholding or promoting her ideas. So you see, the struggle to balance morals with professional ethics has existed for centuries. With professional ethics as food for thought, I'd like to move into misconduct, both academic and corporate. In the academic world, cheating is everywhere. In a poll of 30,000 students led by the Ad Council and Educational Testing Service, they found that 61% of students admitted to cheating. 85% of those students think it's essential. Further, 95% of cheaters don't get caught. Only 41% of Americans think academic cheating is a serious issue, and only 34% of college officials think it's a serious issue. These cheaters are the same people that are now entering the workforce. In a famous case, a master's student, Wilson Crook, at the University of Michigan, discovered a new rare earth mineral in 1975 in Burnett, Texas. He named it Techsite and published his discovery in the journal American Mineralogist. The crystals he found were tiny, 0.1 millimeter, and found as alteration rind between other rare earth crystals in the Clear Creek pegmatite. The Techsite, Pr2O2SO4, discovery turned out to be virtually identical to lab-produced minerals in the lab at U of M that coincidentally disappeared around the same time that Crook graduated. Crook performed X-ray crystallography and chemical analysis by electron microprobe for his thesis. U of M was notified that Crook had fabricated data for his thesis, so they investigated. Professors found that the time log on the microprobe showed insufficient hours to have conducted the analysis necessary. They estimated 600 hours would have been required. Additionally, the thesis data were so uniformly precise that the professors thought Crook had worked backwards from the desired result. U of M invited him back to rerun his microprobe data. Crook returned for a weekend in 1979. He failed to rerun his data, but told the professors he was successful. Unbeknownst to Crook, the department had monitored his computer time and results and found that he had input data that would give him his desired results. When they confronted him, Crook admitted that his results were not developed by the computer program. The professors determined that his thesis was invalid and they revoked his MS. Crook sued, but an appeals court upheld the revocation. The professors then published a discreditation paper stating that Techsite was synthetic. But academia isn't the only place we find misconduct. Let's take a look at these famous examples of corporate misconduct. Volkswagen in 2015. They created a device to cheat the US emissions testing from 2009 to 2015. They paid $1.5 billion in fines, enacted a $10 billion buyback program, and invested $4.7 billion in green technology, and one engineer went to jail. Let's look at Wells Fargo in 2016. They revealed that 5,300 employees had secretly opened over 2 million phony accounts over 5 years in an attempt to hit sales targets and receive bonuses. They paid $185 million to settle a lawsuit and admitting the phony accounts. Their CEO was replaced. And another example, Kobe Steel in 2017 revealed that it had falsified data about the quality of its aluminum, steel, and copper products for the last 5 decades with management knowledge and consent. Their products have been used by hundreds of major companies, including Toyota, Honda, Subaru, and Mitsubishi Heavy Industries, and Japan's bullet trains. The motive for all of these? Greed. An investigative report found a management style that overemphasized profitability and had inadequate corporate governance. Kobe put money above telling the truth to their customers. And yet another scandal, the LIBOR scandal in 2012. Several major banks, including Deutsche Bank, Barclays, and UBS, colluded to illegally manipulate the LIBOR, the London Interbank Offered Rate, which is a short-term interest rate for profit. They had $370 trillion in global average interest rate and benchmarks for lending. The banks raised the value of their investments by millions of dollars with just a single email. The fines were over $9 billion, and several bankers were sentenced to prison. And there's more. Opioid makers in 2019. 6 pharmaceutical companies face potential crimes for shipment of mass quantities of opioid painkillers. Teva Pharmaceutical Industries, Mallinckrodt, Johnson & Johnson, Amneal Pharmaceuticals, and a distributor of McKesson. Just one example is Miami Lucan, who shipped 3.7 million hydrocodone pills between 2008 and 2011 to a pharmacy in West Virginia with only 400 residents. That equates to 8.4 pills per day per resident. The CDC reported in 2017 that more than 2/3 of the 70,000 drug overdoses involved opioids, making them 6 times more common than in 1999. So, why is corporate misconduct so prevalent? Arizona State surveyed more than 1,000 employees asking 2 questions, and they found the following. What causes employees to cheat at work? And is cheating in the workplace becoming more common? For the first question, they found that it was organizational pressure to perform at a high level, especially if there was punishment for not achieving those levels. It forces employees to focus on protecting their own interests rather than the organization's interests. As for the second question, the investigations of the scandals within Volkswagen and Wells Fargo revealed that these employees felt tremendous pressure to perform at high levels. Conventional wisdom has said, winning isn't everything, it's the only thing. Plenty of business leaders believe ethics and honesty are great as long as they don't get in the way of winning. So now I'd like to bring this back to the geoscience world and take a look at geoscience on trial. I found that the L'Aquila, Italy 6.3 earthquake in 2009 was particularly fascinating and disturbing because it led to the conviction of 6 geoscientists. The town had experienced months of low tremors and a 3.9 just 4 hours before the big quake at 6.3 that killed 309 people and injured over 1,500. It destroyed 20,000 buildings and displaced 65,000 people. 6 top geoscientists and 1 government official were tried and convicted of manslaughter. The case was predicated on their failure to predict the earthquake, even though scientific consensus says that this is technically impossible. As you might imagine, there was a huge outcry from the scientific community. Here's the background. On March 30th, 2009, the National Risk Forecasting Commission, seismologists, and government officials met in L'Aquila to discuss the tremors. The public was not present for these meetings. The seismologists noted the possibility that these tremors could indicate a larger quake and that the region had a history of earthquakes, but they never addressed the public. The government official then garbled the seismologist's message and told the community that there was no danger because the tremors indicated an ongoing discharge of energy. Another city official told the public to go home and have a glass of wine. After the quake on April 5th, the town filed suit because the government-appointed scientists failed to adequately evaluate, then communicate the potential risk to the population. They cited that incomplete, imprecise, and contradictory information was provided to a nervous public. The 6 seismologists and 1 government official were convicted in 2012 of manslaughter and given 6-year jail sentences. In late 2015, Italy's Supreme Court acquitted the scientists, but upheld the conviction of the public official. Here's another example of geoscience on trial. La Mesa Geoscience, Inc. in 2003. The defendants in this case are both the corporation and its president, Kenneth Hooper. Starting in January 2000, the defendants raised more than $3 million by selling unregistered securities to over 200 investors. Individual investments ranged from $2,500 to $25,000. The defendants knowingly or recklessly misrepresented a number of material facts to existing and prospective investors. The pro forma projections indicated that investors would recover their principal within 2 to 3 years and then earn profits for at least 5 years thereafter. Cooper announced that these investments would be converted to common stock at 50 cents a share, but they were expected to sell for $2 per share. That's a fourfold ROI. Cooper had no basis for this pricing, no audited financial statements, and no auditor had even been retained. In reality, no well to date has ever returned the investor's principal, much less made a profit. SEC filed charges in 2003, and La Mesa settled without admitting anything, and they paid a $40,000 civil penalty. Here's another famous one that took place in Woburn, Massachusetts in 1984. You might be familiar with the movie A Civil Action that's based on these events. The site became an industrial-plex Superfund site, the most expensive toxic cleanup in history at the time, at more than $68 million. The defendants are W.R. Grace and Beatrice Foods. In the 1950s, Woburn had inadequate and poor water quality supplies and rapid growth. City officials decided to drill public supply wells to supplement surface water from Horn Pond. They needed more wells, but a study in 1958 said that the new proposed wells would have contaminated water. The city proceeded anyway, hoping that the sand subsurface would somehow filter these contaminants that were sourced from local industry. These two new wells were used from 1964 to 1979. Residents complained about foul odors, taste, and pipe corrosion for over a decade. Horn Pond and the city wells sit in an alluvial valley with wetlands at the surface. This is the same area where most of the industry is located, including W.R. Grace's Uniform Dry Cleaning Company and the Riley Tannery that was later purchased by Beatrice Foods. In the 1950s, Riley bought 15 acres in the area to dump tanning wastes, including trichloroethylene, throughout the 1950s and 60s. In 1979, barrels of solvent were found near 2 municipal wells. Between 1969 and 1986, 21 Woburn children were diagnosed with leukemia, a rate 7 times the national average, and 12 of those children died. When the maps of leukemia cases were compared with drinking water distribution, it indicated that the 2 newest wells were the likely culprits. The civil case went to trial, but the jury was not allowed to hear from the families. Further, the complainants had difficulty proving that W.R. Grace and Beatrice Foods were responsible for the contaminants in the groundwater. Ultimately, Beatrice Foods was found not to have contributed, leaving W.R. Grace to settle the suit for $8 million. Neither Grace nor Beatrice ever admitted responsibility for the elevated leukemia rate in Woburn. Despite the disappointing civil case, EPA pursued the issue. They identified 15 acres as the source of the contamination for Woburn's wells. Today, Grace and Beatrice are paying for the largest and most expensive toxic cleanup in U.S. history until the Deepwater Horizon. This brings me to a few legal precedents that affect geoscience in the courtroom. Let's chat about Fry and Daubert. Courts have the role of gatekeeper for the admission of expert opinions. They must ensure that expert testimony reaching the jury or being admitted as evidence meets the basic levels of reliability. For over 70 years, judges relied on the Fry test to determine whether scientific evidence should be admitted into a trial, whether the evidence was relevant to the case, and whether the evidence was generally accepted in the expert community. Fry proved to be a poor standard for new or novel scientific or technological concepts and advances, as well as complex issues. Along comes the 1993 Daubert decision. This is more flexible federal rules of evidence, and it replaced the Fry test in determining whether any expert's opinion is admissible. It's no longer just the scientific experts. If scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion, or otherwise, if the testimony is based upon sufficient facts or data, the testimony is the product of reliable principles and methods, and the witness has applied the principles and methods reliably to the facts of the case. The Daubert decision set two important precedents. One, it affirmed and strengthened the role of judges as gatekeepers. They screen expert evidence to ensure that what is admitted is both relevant and reliable. Judges would decide whether juries would get to hear plaintiffs' scientific evidence. It expanded the federal rules of evidence to include specific, non-exclusive criteria for evaluating the reliability and relevance of both scientific experts and scientific evidence. So judges no longer defer to the scientific community to determine whether expert opinion evidence is reliable, and they can now consider a whole list of factors when assessing the reliability or scientific validity of an expert opinion. So here are the 4 Daubert criteria. Whether the theory or technique involved a testable hypothesis. Can it be, has it been tested? Whether the theory or technique has been subject to peer review and publication. What are the potential error rates and standards controlling the technique's operation? And whether the method or technique is generally accepted in the scientific community. So Daubert allows judges to exclude testimony if there is too great an analytical gap between the data and the opinion proffered. Methods can now be questioned and tested rather than relying on experience or the general acceptance. Methods, when appropriate, must be testable, capable of meeting the test of peer reviews and being published, and not just based on experience. An expert may rely on the work of others, but the testifying expert is expected to justify the relevancy of the work and its consistency with the facts of the case. This may be viewed by many as being overly strict when applied to factors and methodology involved in the geosciences. Since Fry and Daubert, the following court decisions that include Fry and Daubert decisions have had significant impact on the criteria used to assess the admissibility of expert opinions as evidence. Let's look at 3 cases. Wright versus Willamette Industries. Residents near a manufacturing plant brought a negligence action against the plant owner, claiming damage from exposure to plant emissions. Despite evidence of exposure, the court excluded the plaintiff's evidence of causation because they only produced speculative evidence regarding the level of exposure actually hazardous to humans. In other words, a testifying expert cannot provide speculative testimony. Anglotto versus Leaf River Forest Products. The Mississippi Supreme Court dismissed plaintiff's stigma claim because plaintiffs could not affirmatively prove that defendant was the source of the chemical found on their property. The mere association of the chemical with the defendant was insufficient. The expert must explain how the chemical arrived on the plaintiff's property, not just that it was also on the plaintiff's property and could have come from the defendant's facility. As above, association and exposure are not the same as proving that a particular source was the actual cause of harm and damage. And Blum versus Merrill Dow Pharmaceuticals. A Pennsylvania appellate court stated that we do not ask whether the expert's conclusions are generally accepted. Rather, we consider the underlying principle, which must be generally accepted, to be that the methods used by the expert to arrive at their conclusions actually give an accurate prediction. The court concluded that the underlying scientific principle of the plaintiff's expert testimony was not generally accepted in the relevant scientific community. Accordingly, the underlying scientific principle behind the geoscientist's work generally should be identified and established as being generally accepted in the relevant scientific community. Now I'd like to discuss a few of the cases that my agency, the Texas Board of Professional Geoscientists, see. The first case involves permits submitted to the state of Texas for new coal-fired power plants between 2005 and 2009. Governor Perry asked TCEQ to expedite the permitting process for 17 new coal-fired power plants whose permits had been submitted. TCEQ granted conditional approval, but the Texas Cities for Clean Air Coalition was formed to oppose these permits based on degradation to air quality in Central and North Texas, areas that were already non-attainment for air quality. A technical review of the permits by TCEQ indicated that air quality in North Texas would actually improve if these plants were built. A consultant hired by the Clean Air Coalition discovered that the air quality modeling had been completed using the opposite prevailing wind direction. Ultimately, only 3 of the coal-fired power plants were approved and constructed. Was the wind direction an honest mistake, or was it really unethical professional practice? In 2014, a treasurer for a professional geoscience society misappropriated or borrowed funds from the society and used them for personal expenditures. The professional society confronted their treasurer, who was a licensed PG, and reported him to TBPG. The professional society's primary objective was to secure repayment of the funds, and therefore they did not file criminal charges against the treasurer. The professional society worked with TBPG and the treasurer to impose strict repayment conditions on the licensee rather than revoke his license and render him unable to repay his debt. Geoscience reports not signed and sealed. TBPG is seeing an increase in the number of reports submitted to TCEQ that require a PG seal but do not have them. TCEQ is now routinely referring these types of cases to TBPG. When a complaint is opened against the PG, the typical response is, "I didn't know." Bottom line, PGs are required to know and follow the rules that apply to them, so these violations stand. Still under the category of geoscience reports not signed and sealed, TBPG is also seeing an increase in the number of reports submitted to private clients that require a PG seal but do not have them. TBPG is receiving these documents from third parties typically. When a complaint case is opened against the PG, the typical response is, "I thought private clients didn't constitute public practice." Once again, licensees are required to know and follow the rules that apply to them, so the violations stand. This example is geoscience done by a PE firm that's not signed or sealed. Typically, when reports without a seal are provided to either TCEQ or a private client, TBPG will open a complaint against the firm in addition to the licensee. This is also true when PE firms produce geoscience reports that are not signed and sealed. In some instances, no PE would sign or seal a report since they were not qualified to perform the geoscience work. In other instances, the PG that did the work resigned prior to the report being issued, and the firm issued the report without a seal. Lastly, others were under the impression that doing geoscience for a PE firm meant that no seal or signature of any kind was required. These violations all stand. PG license renewals without continuing education. TBPG is seeing a number of continuing education violations, specifically for failure to obtain the required continuing education credits. When a PG renews their license online, they must check a box stating they've completed their CE credits. When audited, if they cannot produce the proof of completing the CEs, they are typically cited with up to 4 violations and a fine of $400. As required, TBPG posts all violations to their webpage. Intentionally selecting inappropriate sample locations. In the next case, you review a Phase 2 environmental site assessment that shows no impacts to soil or groundwater and recommends no further action. The site was a gas station for over 50 years. As you dig a little deeper into the Phase 2, you discover that the sample locations and depths presented in the report do not match the sample depths on the third-party lab report. The lab report indicates that all soil samples were collected at a depth of only 2 feet below ground surface and therefore cannot possibly be representative of site conditions. You reject the Phase 2, but do you report this breach of ethics to TCEQ and TBPG? The answer is yes. TBPG rules require you as a licensed PG to report known or suspected violations. There are many rationales for breaches of ethics. What I'm doing isn't really illegal, or my behavior is in my best interest, or my bonus depends on making this goal, or nobody will ever find out what I've done. Here's a good one: the organization will protect me, or if I don't do this, I could lose my job. The bottom line is nothing protects you from doing things you know are wrong. My favorite quote from C.S. Lewis: integrity is doing the right thing even when no one is watching. I'd like to thank you all for attending today. My contact information is shown here. Please don't hesitate to reach out to me. I believe that most, if not all of you, are in Texas, so please help TBPG by reporting substandard geoscience and practitioners. Complaints can be submitted anonymously. I'll close by saying, do the right thing because someone is always watching.